This is case number 2022 CA 1128, Joseph Petito, Nicole Schmidt versus Christopher Laundrie, Roberta Laundrie. If we could have the attorneys please make their appearance.
Good morning, Your Honor. Patrick Riley for Joseph Petito and Nicole Schmidt.
Good morning, Your Honor. Matt Luca on behalf of Chris and Roberta Laundrie.
And Mr. Luca, we're here on your motion for protective order, which is at document identification number, or DIN 51.
Yes, thank you, Your Honor.
You may proceed.
Your Honor, would you prefer that I speak from the podium or?
I don't care.
Doesn't matter.
Whatever makes you feel most comfortable.
Thank you, Your Honor. So, Your Honor, obviously you're very familiar with this case, so I'm not going to go through the history of it. We filed this motion for protective order. We have the depositions for the Laundries scheduled coming up. And the purpose of our protective order is that we want to limit the scope of those depositions. Now, we're not asking the court to preclude those depositions entirely, which was the focus of the cases cited by the plaintiff in their response. And frankly, most of the cases in this area relate to completely precluding depositions. Rather, we want to focus the depositions on the relevant period of time identified in the amended complaint, the attorney's statement, which is the core of the cause of action in this case, the intent of that statement, the knowledge of the Laundries during the period of time of that statement, and any actions they took during that time, of course, subject to the attorney-client privilege or any other applicable privileges. Now, the plaintiffs in their response state that they want to inquire into the relationships between Bryan and Gabby, between Bryan and his parents, between Bryan's parents and Gabby, and between the...
Let me ask this, because ultimately, if I were to grant your motion, I'm going to have to write an order that lays out the contours. So what date range are you talking about?
So, Your Honor, I believe in the complaint, the plaintiffs alleged that on August 27th that Bryan notified his parents about what happened. Now, understandably, when we have the deposition, that may or may not be the specific date, but certainly we're fine with, from the period of time when Bryan first notified his parents that something happened, at least.
So under your proposed limitation, any communication between the plaintiffs and the defendants that occurred in the year or two before would not be allowed?
Well, Your Honor, certainly if Mr. Riley wanted to ask the defendants what their relationship was at the time that that statement was made by their attorney, I could understand how that would be reasonable, but I don't think we need to meticulously scrutinize their entire relationship up until the point where this event occurred. It's just simply not relevant to the cause of action. Whether or not they had a good relationship, a bad relationship, whether or not they spoke 10 times or one time, is really frankly of no moment in terms of whether or not that statement made by their attorney in the context as it was made at the time of those facts. That's really what this cause of action is about, not whether or not they had a good relationship or bad relationship leading up to that point.
So is that a yes or a no to they would or would not be allowed to inquire into those relationships that existed?
We would say that they could inquire into the relationships as they existed at the time of the statement, but inquiring into all their past and everything like that, we would ask the court to preclude that.
You can continue with your argument.
Thank you, Your Honor. Your Honor, as I just said, really those relationships, the conversations that they may have had that occurred before the event between Bryan Laundrie and Gabby Petito and Bryan returning home, and really the time period after Gabby Petito's body was discovered, really have no bearing on the cause of action. Things such as whether or not they ever saw Bryan and Gabby argue, whether Gabby lived with the Laundries and what their relationship was like during that time period, or how many times that the Laundries spoke with the plaintiffs, really make no difference in ultimately proving their case. Now the plaintiffs stress in their response that relevance of this information is really of no moment, and really because asking these questions at the depositions and whatever answers they get wouldn't be burdensome, oppressive, annoying, or harassing. Now, in in a couple of the cases cited by the plaintiffs in their response, first, HEPCO Data versus HEPCO Medical, which is 301 Southern 3rd at page 410. And that court said, of course, the scope of discovery must be relevant, and the information sought must be reasonably calculated to lead to the discovery of admissible evidence. And again, in Kiker versus Lopez, 718 Southern 2nd at page 959, relevance goes to the issue of whether information requested is discoverable. So certainly, relevance is the first threshold that must be met, and then whether or not that information is burdensome, oppressive, and annoying or harassing is ultimately what must be considered. Because in a typical case, irrelevant questions during a deposition, they come and go, they happen all the time, certainly. However, Your Honor, this is far from a typical case. First of all, both families have been through a horrific experience. And just speaking for the Laundries, they had to experience their son doing something terrible, and then he killed himself. Living through that nightmare obviously created a lot of emotional trauma at the time, and they still carry a lot of emotional baggage as a result. Now, under normal circumstances, asking questions about that event would be very trying. But if you consider in this case that this tragedy occurred under intense media scrutiny, the facts underlying this case probably were the biggest news story in 2021. And certainly, due to the COVID pandemic, a lot of people were watching TV during that time, and it was followed on a daily basis by the media.
Mr. Luca, normally I would see if someone is wanting protection for taking a deposition for medical reasons, I usually get a doctor's note of some sort, but I don't have that here.
I understand, Your Honor, and certainly we're not trying to suggest that the Laundries have some sort of medical condition or a psychological condition that would prohibit them from answering questions, giving a deposition. It's just that, under normal human circumstances, answering questions about these kinds of things are very difficult.
Well, you say this is a different type of case, but why should I treat it any differently than any other case that I have?
Yeah, I understand, Your Honor, but in this case, we do have to expect that eventually these depositions are probably going to make it into the public realm, one way or another. In a typical case, nobody really pays that close of attention to the depositions. Nobody tries very hard to get them. In this case, it's almost assuredly these depositions are going to be out there at some point. And this subject matter
isn't every single deposition that gets filed in Florida on the public record, isn't that available to the public just at a click of a mouse?
Yes, Your Honor, certainly everyone that gets filed. Yes. Now, we don't know whether these depositions are going to get filed or not, and what use is going to be made from them, whether they would be presented at trial, anything like that. But, Your Honor, we're trying to protect the Laundries at this point from delving into subject matters that are very difficult, that are embarrassing, that are oppressive, just under the circumstances. The Laundries had a film crew parked outside their house for 30 days, scrutinizing every time they got the mail, every time they filled their car up with gas. So certainly these depositions are going to be picked apart, and it's going to, there's going to be a lot of vitriol online toward them, and we're really just trying to save them from having to answer questions that are irrelevant, that don't necessarily go to support the cause of action, which is very limited, and could subject them to really unnecessary scrutiny, harassment, media attention that really we just want to prevent them from having to go through again. Thank you, Your Honor.
May it please the court. Good morning, Your Honor.
What counsel's asserting is that there should be a prior restraint on our ability to question the Laundries in this case. The case is not about the emotional distress that the Laundries suffered, far from it. This is about the emotional distress that my clients suffered as a result of their conduct and their statement. In terms of media coverage, they themselves have asked for media coverage. Attorney Stephen Bertolino, who represents them in this case, is in front of the public, in front of the press on a regular basis, so they invite it. That's not a good argument.
Same question to you. I mean, why should I even consider whatever the media does or doesn't do?
I don't think you should. I'm simply responding to what he says. I don't think that's an issue. I don't think the fact that these questions are difficult for them and might embarrass them and cause them distress matters. That's what litigation is all about. It happens. Parties come into court when they're adversarial. Parties file cases against one another in difficult situations where there's animosity, where there's emotion. This case is no different in that regard than any other case. It's a burden that the defendants have in this case to show good cause. And I did cite the court, and I appreciate that Mr. Luca pointed out the HEPCO case, because yes, the HEPCO case says that information and depositions has to be relevant, but then the conclusion in that case is, even so, relevancy is not a proper ground for protective relief under section 1.280C. And it cites two other cases, a Dees case, which upheld the circuit's court finding that the information sought to be protected is not related to any pending claim and is not reasonably calculated to lead to the discovery of admissible evidence, is not sufficient to issue a protective order. And then there's the Kiker case that's also cited, holding the argument that the information is not relevant to the issues in the lawsuit does not satisfy the moving party's burden to show that producing the requested information would subject him to annoyance, embarrassment, oppression, or undue burden or expense. In all of the cases that were cited by the defendants, except for one, there had already been a request for production or a subpoena that had been proposed or something which specifically identified the information that was being requested, so that the opposing party then have an opportunity to say why that information shouldn't be discoverable. In this case, the defendant's not pointing to anything that we asked for at this point. There hasn't been a question posed yet. There's nothing in the deposition notice that says what the areas of inquiry are going to be. It's just with regard to this particular lawsuit. I don't know how the court could fashion an order in this case to limit, as the defendants are suggesting, the questioning in this particular case. Based on what they're saying, I couldn't ask their date of birth. I couldn't ask what their address was. I couldn't ask what their educational background was. None of the typical background information that you ask in a deposition would I be permitted to ask. Counsel indicated, except for the relationship between the parties from August 27 until I believe it was September 17 or September 19, I can't go outside of that time period. That's overly restrictive, and it does not address what the rules permit when a protective order is permitted. There's been no good cause shown in this case to entitle the defendants to a protective order, because I'm not even sure what they're saying we shouldn't do other than go beyond, I think it's a 20-day period. Maybe it's 24-day period. So I don't think they've shown good cause. If there's issues during the deposition, then we can address that during the deposition. But I don't see how the court can look into a crystal ball or be asked to look into a crystal ball and say, here's the questions that might be asked and you're not permitted to ask them. Thank you.
Mr. Luca.
Thank you, Your Honor. And I understand, as Mr. Riley said, that, you know, when plaintiffs are in court, they subject themselves to discovery. Obviously, we're the defendants here, so we didn't want to be in court. But nonetheless, I do think it's important to note that this cause of action is so narrow. It's very narrow. This isn't, you know, a business dispute about transactions that occurred over a lengthy period of time. It's very specific as to this one statement and what the Laundries knew, what their actions were with regard to issuing that statement. So in that context, Your Honor, we don't want to turn this deposition into an expose of the Laundrie family over the years and what Bryan was like growing up, what their relationship was with what his relationship was with his parents. How, you know, what
You can continue.
Oh, I'm sorry, Your Honor. So, Your Honor, that's really what we're trying to prevent here. It's just to establish some guardrails so that this doesn't become, something other than really what it's intended to be, which is for the plaintiffs to establish facts that relate to their cause of action. You know, this is not a moment for, somebody to create, fodder for online media reports or to make a movie or something like that. That's really not the purpose of this deposition. It's to uncover facts that are relevant to the cause of action. And in this case, really, facts outside of that time period that's defined in the complaint really have no bearing on that statement. Nobody contemplated that statement prior to the facts alleged in the complaint. And obviously, anything that occurred after that statement really is not important either. You know, with that idea in mind, Your Honor, we would like you to issue an order that confines the questioning to facts that relate to that specific time period as identified in the complaint.
Thank you. The court has before it the motion for protective order filed on behalf of the Laundries at DIN 51. The court's going to go ahead and deny the motion. The court notes that there really has been no showing of any prior misconduct by the plaintiffs. We normally would not issue such an order without either some showing of something going on other than the fact that there's a lot of media scrutiny. The proposed limitation in the court's view is overly narrow and would actually preclude directly relevant evidence gathering in this particular case under the allegations as alleged. And the court cannot find that there has been a showing of good cause. Therefore, the court will deny the motion, and I'll do the order. Thank you. Anything else?
Your Honor, and I don't know, I'll discuss this with Mr. Riley, and I don't know if it's necessary, but would Your Honor entertain something like having this deposition supervised by a special master or something like that?
I've done that only a couple times, and it's usually when the lawyers aren't working along and getting along with each other, and everything I see, the two of you are getting along
We get along just
famously.
fine, Your Honor, so I really don't think it'll be a problem, but I just wanted to throw that out there in case, if you felt like it was necessary, or if Mr. Riley and I thought it was
trust
necessary.
Mr. Luca in your professionalism and in Mr. Riley's professionalism. Yes, there's media here, but at the end of the day, you're both lawyers. You know how to conduct yourselves. You know the rules. And so I trust both of you.
Thank you, Your Honor.
Thank you, Your Honor.
Anything else?
No.
No, thank you.
Thank you.
Thank you.
Real quick, before you guys get off the record, can I just get the names of the lawyers again one more time?
All rise for the recess.
So it's Matt, M-A-T-T-L-U-K-A, for the defendants.
And Patrick Riley, R-E-I-L-L-Y, for the plaintiffs.
Okay, thank you very much.
Thank you.